guys. So, today should be the last witness. I don't know if there's going to be rebuttal if anybody, I feel like rebuttal would be maybe Detective Flores, because we heard he's sitting in the gallery. Lewin asked him to stand up yesterday. But we're supposed to get one more witness from the defense. I am very excited to see this play out. Linda, let's get the tweet up here. Let's see. Let's go check out Linda Kenny Baden. I'm going to drop her link to her ex in the chat here. What does Linda say? What does Linda say? And Linda's the one that broke the news about the starter gun defense. Where are we? Where are we? So, Justice Serve TV can report that defense expected to call a rep from my favorite place, Dunkin' Donuts. So we might have someone come in, and we did hear Takapina say this witness would be very short. But we were talking about this when Relly gave the testimony that, he leaves the scene after the fight. He goes back to the Lowe's hotel. He links up with Lydia. They get in the car, and it's like his car, but it's her car. And then they drive to a Dunkin' Donuts, and they get a Dunkin' Donuts bag and a pen. And then they together go back to the scene, all within an hour's time frame. And he gets these shell casings. So, if he truly did all this within that hour, he's not on any of their surveillance footage that was captured within that time period at the scene that we know there's surveillance pointing at. But then he brings the casings to the police 2 days later on the 8th, and according to the officer, Kirk Anderson, he brought the casings in a black plastic bag. So, when that all came out, we were talking about it. The chat was like, what? This is California. What Dunkin' Donuts is going to use a plastic bag, let alone a non-branded plastic bag? And it's California. California's done away with a lot of single-use plastics. On top of that, we looked up some of the hours of operation. And we didn't see any 24-hour Dunkin' Donuts in this area. So that would mean he'd have to drive very far to find a 24-hour Dunkin' Donuts, which is weird if you're just looking for a bag, and drive all the way back. It was also COVID era. It was 2021, so hours were weird. It's one of those things where it's why would you make up a detail like that? So maybe that's who our witness is going to be. So this is, I'm pretty excited about this. I'm celebrating for the occasion. I might be super hyped up because this is a lot. I don't know what I got myself into. This is a lot of coffee. And that's it, Miss Bailey. Not that I know of. There are 24-hour Dunkin' Donuts, but they're not everywhere, and nothing in the radius of Hollywood and Vine is open 24 hours. So, Factual Lie is running in here with the donut emojis. Also, guys, big thank you to the chat here. Cutthroat Radio says Cat, Chat, and Mlat. I felt all the love yesterday, and I'm truly thankful to be a part of such amazing people in the chat. Thank you to the entire chat community. So, thank you guys for showing the love yesterday. It makes a difference to know that people are listening to you, people care, and that people want to see you in a good mood, happy, even if you're going through rough things. Also, thank you, Kat, to the entire chat and Mlat. I appreciate all the condolences. Flowers and hearts. I was overwhelmed with so much joy when I watched the playback and seen all the love to me and my fam. So shout out all day here to Cutthroat Radio. I dropped his link in the chat. We need you to start creating again, start doing your podcast again. So when you get through it, we are here for you. You guys go check out that channel and show some love. Although new content right now, when people get through the things that they're going through when they come back, it's always better than ever. Also, we've got Gail in the house here from Baltimore. Hey there. A little bit up north. Are you getting that cold winter weather, or is it just north of you? Yeah, Brittany thinks it's her car, let's be real. Yep, I don't know. Is Dunkin' Donuts even open at that time? Leah's dad says, can't wait for the D&D employees to be we don't even have black bags. Yeah, what's the questioning? Is it gonna be like someone that worked that day, or is it just going to be someone that's familiar with the operations of that particular, the closest location? In like a regional manager could say like none of our locations were open past the time frame that the incident allegedly occurred at. So there's no way someone could have come into one of our stores, and we don't use black plastic bags. So what does that take? Like a few questions to establish who the witness is, and then like 3 substantive questions on Dunkin' Donuts hours and their branded materials. Like I don't know. I don't know. Um, I wouldn't be surprised if Ills decides, if they call Ills and he testifies via Zoom. I don't know, but who would be calling him? Who would be calling him? Hey to Nicola. I got my steps in this morning because of you. I was thinking about you. Oh, Mia says, or maybe it's Mai, says I'm no longer getting notified when you're live. It does that. I don't know why it does that. That is a big YouTube thing. Yeah, and Gail, okay, so you are getting that storm, Gail. A lot of the early birds in the chat were mentioning cold weather. I think Mary, if you're in here, Mary said she was getting like up to 8 inches of snow, I think, one of the early chats. So I don't know. If you like snow, I'm glad you're getting some, Gail. If you don't like snow, sucks that it's hitting you there. Sucks that it's coming your way. So HTX Cass, videos only showed / heard 2 gunshots, but there were multiple casings. Did I miss this explanation? So there were 2 casings. There were 2 casings, but Relly initially reported 3 to 4 shots, and then in a recorded call with Wally, he said he hit me 5 times or something like that. But there were only 2 casings brought in. Yeah, a bit hard to follow though, because earlier in the case beginning, I feel like they were throwing up pictures of the casings, and they're throwing up pictures of the ammunition that was in the magazine found at Rocky's house. So it's just kind of like, if you think of the visuals, I can see why brain would go to mush. Yeah, when Michelle says, I don't think we need to hear Ill's testimony, would much rather hear Rocky. I would rather, if I was to defend strategically, I don't think we need to hear from either of them. But I do get the sentiment that, one, having Rocky on the stand would be like a spectacle in and of itself. Especially, we've seen his facial expressions at Lewin. Let me make sure this isn't live, by the way. Yeah, we're still not live yet. But we've seen his facial expressions. Granted, like the most iconic tense moments have been when the jury's not in the room. Maybe he wouldn't do that on the stand. But I think it would just bring this trial to a level. I didn't even think we could get to where we are, but it would bring it to another level. And I do think there's some part where the jury wants to hear certain things from the horse's mouth in certain cases. Maybe this is one of them. If I was on the jury, I'd be curious, but I wouldn't need to hear from him to believe like what I've heard from the other witnesses. Yeah, a lot of DMV members here in the chat. DMV Collective, I love this, Trakeisha. Oh my goodness. Leah's dad says Lewin's gonna talk to Rocky crazy and Rocky might respond. I don't think it's worth the risk. Right. Holy moly. Hey to Jazzy T, good to see you. Yeah, Danny, Rocky would probably curse him out. Yeah, seems like we're building a consensus in the chat here. It would be a spectacle, maybe not the greatest strategy. Let's see, Court TV maybe? Yeah, so Court TV, they should have they had their, so the judge said we're starting at 10 a.m., which would be 10 minutes ago. Court TV has had their stream started or scheduled for 30 minutes before the start time, which isn't unusual for them, but usually they have the stream going and it's live, but it's just this placeholder image. But they didn't even start up yet, so. I don't see any updates from, let's see. I don't really see any updates from anyone. It is still like, you know, everyone could just be filing into the courtroom. Do you think if this is a Dunkin' Donuts witness, do you think they brought donuts? Oh my goodness. Yeah, I'm with you on that Project Ban shirt. I definitely don't think Rocky should testify. I agree. If he does, I'm gonna be watching with all. I'm gonna be like glued to the screen. But I really think that that was just something the defense team was throwing out there to scramble. Maybe not even Mr. P, but specifically to scramble Lewin up. Like he was all like, Judge, we're not gonna have time. I don't know. Oh, did we just refresh finally? All right. So let's get over here, get some captions on. Close the chat because the chat always slows things down. Close the law and crime chat, not you guys. You know, this is pretty clear today. And there's a face here that kind of looks like Judge Arnold. It's just because there's a mustache showing. That's why I say it looks like Arnold. Oh my goodness. Was there anything else super interesting? I've got a little like law nerd thing to nerd out about over lunch. I mean, it's kind of something that frustrates me, but really interesting to read. Doug Gladden, he's an appellate lawyer over in Texas and Georgia. Love a lot of the stuff he talks about. Yesterday, you guys were asking, we talked about Brady evidence a little bit and some examples of what could constitute Brady evidence. Well, there's a big proposal in the Texas appellate world where they want to reduce the discovery obligations of the state. So we're going to take a look at that. He does a good analysis on it. I guess we'll do that on one of those like 15-minute breaks. But if you guys want to check it out in advance, highly recommend you guys follow him. I learned so much, and he posts a lot of interesting stuff. You guys may have heard me talk about, you know, the prejudicial effect of, think of Detective Dennis on the stand when he blurted out that Yak had just gotten out of custody. You know, there's a prejudicial effect of the jury having the imagery or understanding that the defendant is in custody. It's extremely prejudicial. And I had mentioned at that point in time a case that recently got overturned. It was a Texas case. The defendant, a police officer on the stand, was asked to identify, you know, and is this person in the room today? And he said, yeah, over there with the green dress and the shackles. So he pointed out, an officer who's experienced in testifying, pointed out in front of the jury that she was sitting there in shackles. And she was convicted, but her case was, the conviction was overturned because of that identification. So he, like, I learned so much from, like, I don't live in Texas, but I like to hear stories like this and look at his analysis. But Doug Gladden is where I heard of that from. So he's a great person to follow. Let's see. Kay Schmidt says Texas is going backward in time. It's like that. It can be like that sometimes. Good to see you, Allegedly Maybe. Allegedly Maybe says hey to the chat. Hey to Destined to Be. Yeah, Banjo-Kazooie, this is such a good question. So if Joe plans to have like a minute of questions for this witness, he says it's going to be super short. How long will the prosecution try to cross this witness on? He's going to be like, Your Honor, it's last minute. We deserve a thorough cross-examination. So, who knows? Who knows? Let's see. And hey to Vahydro. We have noise.
No additional witnesses?
No.
One moment, Your Honor. Paul has a good suggestion, maybe this will work. We are happy to add, if you would like, in the sentence, People's 32 did not come from a crocodile. That's the case, exactly what you want.
Wait a second. Okay, we're just going to make, Judge, we call our expert real quick. We're trying to save time, if possible.
Let's,
No, hold on.
Take it away, it takes time.
let's do it after the jury has left.
Okay. Because we're not coming back to one, can't be to one.
But wait, if we agree on the stipulation,
Then we would read it, and then
we agree to them and you do the charge, and then they could leave good,
Well, that's
right? Or we're going to make them leave.
Well, we're going to have to go through instructions because we haven't done it yet. We can't just read to the jury, we haven't done it.
Right.
We gotta go to the jury.
We got to leave either way.
They got to leave for the day.
No.
How long will you anticipate it will take us to... Thank you.
I have a pretty good grasp on the instructions. I'll listen to what you both have to say. It shouldn't take more than a half hour to go through the jury instructions and reading them to the jury.
All right, so it seems like there was they worked something out. And again, yesterday we were talking about, there's a court holiday tomorrow, and they're closing out early today. A juror has to do something at 3 p.m. Pacific time anyway. And with that leaving just Thursday and Friday left, Lewin was saying something about going into next week yesterday, and I don't think the defense wants that at all.
Mr. Mayor's his right to testify?
Yes,
Have you also discussed his right not to testify?
yes, sir.
All right, Mr. Mayor, do you hear what Mr. Takapina just said?
Yes, Your Honor.
Do you agree with what he has said? Just said?
Absolutely, Your Honor.
You understand that you have a right to get on the stand and give your side of the case. You understand and accept that.
I do understand and I accept.
Also, you have a right under the Fifth Amendment to the United States Constitution not to testify. You cannot be compelled to testify. It's totally your decision to either get on the stand or waive your right to testify and not testify. You understand that?
I understand.
Okay, which right do you wish to take advantage of? The one to testify or the one to not testify?
I'm on my right to not testify.
All right.
No testimony.
All right. So do you in fact waive your right to testify in this case?
I do, in fact, Your Honor.
Counsel George.
Yes.
I believe that Mr. Mayor's waiver is knowing, free, and voluntary. I accept it. All right, let's have the jury come in. They'll be told there may be a witness at 1:30. In the interim, the defense, you can ask for your exhibits to be admitted. I understand there's going to be no objection. The people have one additional exhibit. That will be moved in. Then I want to give the jury a 45-minute break. In that period of time, we will discuss the jury instructions informally, after which we will come out and formalize them on the record. After that, I will read the jury instructions to the jury. At some point, if the jury instructions go beyond 1:30, I'll stop reading the jury instructions so the remaining witness, if he testifies, we can take him out of order, and then I will resume the jury instructions. And that will be all for the day. Summations will be on Thursday. Is that the understanding?
Yes, Your Honor.
Sir, you mentioned another exhibit from people going there.
Yeah, they marked a DVD. It's the DVD from Complex.
Oh. So it was something different, that's all.
Yeah, they're talking about an
All right,
expert.
let's have the jury.
All right. It's a little weird because you would think like the time frame 1:30 sounded like a rebuttal witness, but it seems like maybe they're just having trouble getting a witness in on time, or they still haven't gotten word back that they can get there. Or maybe they haven't decided if they actually want to call this witness. So, but whatever it is, it does seem like a short, quick witness. They'd have to be done with them by 3. So, Shauna, so I don't think they'll come back with deliberations today because we didn't have closing arguments, so we won't even start deliberating today. But I do think that the defense, we heard some talk of stipulations. I think that they're making strategic decisions to give the jury an opportunity to start deliberating Thursday and have all day Friday. That way they can get this done and over with, possibly before the weekend. I mean, I think it'd be pretty crazy. This is like a 2-week trial if they were able to start deliberating Thursday and couldn't come to a conclusion or decide that they were hung by the end of the day Friday. Okay, so thinking it's the prop gun holder, the guy from New York.
Record, our jurors have returned, all parties and counsel are present. I understand that Mr. Tacopina, that there are no additional witnesses to be called by the defense.
Yes, Your Honor. Defense rests in this case and we move forward.
All right, that would be A through EE. Any objection to A through EE?
No, Your Honor.
A through EE are admitted for the jury's consideration. There is one remaining exhibit that the people marked, which was number 44.
The people moved people's 44 into evidence as well, Your Honor.
No objection? All right, all of the exhibits are admitted for the jury's consideration. What's going to happen now is, I wasn't sure if we were going to have more witnesses or not. There may be one at 1:30, I don't know. But, so we don't waste a lot of time. We are going to talk about the jury instructions informally in the office. That'll take about half hour, thereabouts. Once we're finished, then we're going to have you come back into the courtroom, and I'm going to read the jury instructions. If there is a witness at 1:30, if I am still reading the jury instructions, I'll stop the jury instructions. The witness will testify. Once the witness is finished, then I'll resume the jury instructions. The jury instructions are going to take me about 35, 40 minutes to read. For those of you note takers, there's no reason to take notes because each one of you is going to get a package of jury instructions in the jury deliberation room. And as long as I'm talking about jury deliberations, you will not be deliberating in the jury deliberation room on this floor. You will be deliberating in the jury deliberation room in Department 115, which is on the 11th floor. So when you finally begin deliberations, you'll be escorted to the 11th floor into the jury deliberation room. Department 115 is my normal courtroom. So that's where you'll be deliberating. Once you arrive at a verdict, the verdict will be read in here in 102. Okay? All right, so it's 10:30, actually 10:24. I'd like you all to come back at 11. Be outside the courtroom doors at 11, as close to that time as possible. I'll begin reading the jury instructions. So there's no reason I won't be able to finish it before 12. So leave all your materials on your desk. Remember, do not talk about the case. The case is not over. You have not been released to deliberate.
Don't talk about Og.
So leave everything to yourself. All right, we'll see you at about 11. I'll stay back.
Yeah, so this seems like a rebuttal witness, but he also said out of order.
Could you, I don't know, that's why I'm asking this question. What happens with the alternates?
Oh, no, that's a very good question. Once the jury begins to deliberate, you and the other 3 alternates, you will not be in the jury deliberation.
Right, I understand.
You will have to be close by because if we need to summon you, you need to be here in short order. You will only go into the jury deliberation room if one of the jurors has to leave the case. But you will be in the jury box during jury instructions and during summations.
And can I just get a clarification for what you mean by close by? Are we allowed to go home?
No. You can be, I would want you to be able to be here in 5 minutes. You can be in the hallway, you can be in the jury assembly room, you can be in the cafeteria. But if we need you quickly.
Okay.
All right, then we'll see everybody at 11. Come on back, let's go back.
It sucks. It seems like they're going to do this in chambers, so we won't be able to hear the jury instructions. However, he does say that he plans to be done reading the instructions by noon. It is 10:25 their time, so, and he thinks it'll take him about 45 minutes to read the instructions. So it seems like he only plans to take about 45 minutes to deal with Takapina and Lewin discussing the jury instructions. Now, we've gone over this several times. This is the model jury instructions here. I'll link it in the chat. Again, what they're charging under here is 245B, so only certain sections will apply. And they're probably going to have to decide, you know, what do we actually need to define? They might define force likely, what force likely means. Here we go. So, for example, the terms application of force and apply force mean to touch in a harmful or offensive manner. The slightest touching can be enough if it is done in a rude or angry way. Making contact with another person, including through his or her clothing, is enough. The touching does not have to cause pain or injury of any kind. The touching can be done indirectly by causing an object or someone else to touch the person. So we heard a lot of focus and emphasis from Mr. P, the prosecutor, during direct and redirect of Relly on the, you know, the pistol to the stomach testimony, right? That would be indirect touching because it's not really Rocky's hand touching his stomach. It's the object, which happens to be a firearm, pushing up against Relly. The people are not required to prove that the defendant actually touched someone. I'm sure Lewin is going to push to include this. This is pretty small. Let me make this bigger. The people are not required to prove that the defendant actually intended to use force against someone when he or she acted. No one needs to actually have been injured by defendant's act, but if someone was injured, you may consider that fact, along with all the other evidence, in deciding whether the defendant committed an assault, and if so, what kind of assault it was. Intoxication's not relevant in this case, so that wouldn't be included. Right, I don't think we had any testimony at all that people were, like, drinking before this happened. Great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. We don't need deadly weapon other than a firearm, because even if somehow John wants to try to argue the starter pistol, we should have a lesser included about it. It's a different statute. It's defined by California code as less than lethal. So we don't need the inherently deadly. They're going to skip this because a semi-automatic firearm is already known to be inherently deadly. So the jury doesn't need to be the fact finder on the inherent deadliness of a semi-automatic firearm. They'll simply be asked to fact find whether or not a semi-automatic firearm was used here. Let's see. These aren't relevant. And then we get into bench notes, right? So those are the definitions that they'll have to go through and determine. The main thing will be the defendant did act. Well, the defendant is charged in it's 2 counts of 245B with assault with semi-automatic firearm in violation of Penal Code Section 245. To prove that the defendant is guilty of this crime, the people must prove that the defendant didn't act with a semi-automatic firearm that by its nature, so this is inherent, would directly and probably result in the application of force to a person. We just looked at the definitions for that. I don't see them in the courtroom, you guys. Because it's still on this. Does Court TV have it? Oh. Yeah, Court TV is on the logo as well, so I don't see them live. So back over here, let's see, we don't need these because it's without, they're going to choose this one because it's already with a weapon. But also, the force used was likely to produce great bodily injury. The defendant did that act willfully. When the defendant acted, he or she was aware of facts that would lead a reasonable person to realize that his or her act, by its nature, would directly and probably result in the application of force to someone. And when the defendant acted, he, she had the present ability to apply force, and then with a semi-automatic firearm to a person. So they'll parse this up to make it match the facts of the case. And then this part, guys, we've talked about this. Give element 5, we're going to talk about element 5. Give element 5 when instructing on self-defense or defense of another. So, and the jury has to find all these things. And if they just decide to give element 5, which I think they should and will, the defendant did not act in self-defense or in defense of someone else. Someone commits an act willfully when he or she does it willingly or on purpose. It is not required that he or she intend to break the law, hurt someone else, or gain any advantage. And again, we went through these definitions. They're going to probably be arguing about which of these to include or not include. And there are a bunch of bench notes. And we talked about this self-defense one like a bunch of times, but again, instructional duty. This is the duty of the court, the judge. The court has a sua sponte duty. They must do it even if neither party requests it. The court has a sua sponte duty to give an instruction defining the elements of the crime. So they've got to give the jury instructions, including all the elements above that are applicable. If there is sufficient evidence of self-defense or defense of another, the court has a sua sponte duty to instruct on the defense. So if there's sufficient evidence of self-defense or defense of others, court has to give this element 5. They have to read out this element 5. Now, this to me is the most helpful thing in this entire case for ASAP Rocky, because it doesn't really matter whether you believe it's a semi-automatic firearm or a starter pistol. Number 5 gives a pathway to acquittal even if you think it was a real gun, a real firearm. There's still a pathway to acquittal if you think it was justified. Where were we? Bench notes. So give bracketed element 4 and any appropriate defense instructions. What was bracketed element 4? How do they do that? Do they mean this? Or maybe they mean down here. 1, 2. I don't know what they mean by bracketed element 4. So, all right. All right, so the bracketed definition of application of force and apply force is something that a party needs to request. So that bracketed definition that we read, give the relevant bracketed definitions unless the court has already given the definition in other instructions. I don't think we got instructions at the beginning on this, so this would happen now because it hasn't been done. In such cases, the court may give the bracketed sentence stating that the term is defined elsewhere. Give the bracketed phrase that is inherently... give the bracketed phrase that is inherently deadly or one, and give the bracketed definition of inherently deadly only if the object is a deadly weapon as a matter of law. So again, the jury doesn't need to decide that a semi-automatic firearm is inherently deadly. It's already decided to be inherently deadly as a matter of law. Give the bracketed portion that begins with, in deciding whether, if the object is not a deadly weapon. Okay, so this is irrelevant here. We wouldn't see this in this instruction. This isn't relevant either because it would be for not an inherently deadly weapon. All right, so this part, the second sentence of the great bodily injury definition could result in error if the prosecution improperly argues great bodily injury may be shown by greater than minor injury alone. They're citing they're actually saying compare two different cases, People versus Medellin, and People versus Quinones. So the first case says the definition was reasonably susceptible to prosecutors' erroneous argument that the injury need only be greater than minor. So a bit more than minor. I don't know, how would you... I don't know if this is going to come into play, but I would argue that scrapes are minor because it's consistent with simple assault, not felony assault. So, the second case upholds instructions containing great bodily injury definition as written. So the second case here, in that case, they instructed with the term great bodily injury. And then they cite a ton of case law. And then lesser included offenses. This is important, and this is so what I wish we could hear Lewin arguing. So, 240, under California Penal Code 240, that's the assaults. That's where all the stuff for assault is laid out. Assault with a firearm is under 245. So we're charging under 245B. What could be considered a lesser included? Assault could be a lesser included. What do they say here? Assault with a firearm is a lesser included offense of assault with a semi-automatic firearm. So for example, if we're not sure it's a semi-automatic firearm, but it could be another firearm, we could also do a lesser included of assault with a firearm. But assault with a firearm would not include a starter pistol. A misdemeanor brandishing of weapon or firearm under Penal Code Section 417 is not a lesser and necessarily included offense of assault with a deadly weapon. So John Lewin can't just run around now and say, you know what, we want to also let the jury consider brandishing in case they don't find assault. We want them to consider brandishing was enough. Can't do it. Let's see. And then they just got some more, like, the books here that help you go through criminal law and instructions. So again, if you want to read this, check this out here. Pop Tart's like, this should be a 5-minute deliberation. And then double check over here. We're still out of the box, not in the loop here. And nothing, I don't see. Mel is funny. Taco defense rests in this case. You guys make sure you're going and checking out Mel. Also, big shout out, hold on, our sponsors here, our QVC, our Chloe VC. Hit the like, then grab some delicious really hot sauce. Yeah, it's right in the courtroom cafeteria. So, even the alternate jurors can take advantage of this great offer today. Warmer than a grazed wound. Pairs well with honey-baked ham flavor Relly Jelly. $4.99, 30 million yen shipping and handling. Get it while it's hot. How much is 30 million yen? Oh, wow. That's still almost $200,000. So, oh boy. Yeah, I don't think it's gonna be like a 5-minute deliberation. Because I do think people like read the instructions. I don't know how long that took me to go through, but I mean, probably more than 5 minutes, right? So. Oh, so Bama Law. How did I get the bench notes? So this is actually published as part of it's a huge document. So if you go to this link, you can pull, and I think it was like updated in 2024. It gives you this 2,500 page monster, and a lot of the different charges have the bench notes. So my guess is that it's something that legislative wise they said, hey, you guys should put this together. I don't know how we got here. Maybe here we go, Bama Law. Let's see. These instructions represent the work of the task force on jury instructions appointed by Chief Justice Ronald M. George in 1997. Our charge was to write instructions that are both legally accurate and understandable to the average juror. The 8-year effort addressed a need for 8 years. The 8-year effort addressed a need for instructions written in plain English and responded to the specific recommendation of the Blue Ribbon Commission. That reminds me of the Blue Ribbon ice cream. On jury system improvement that observed. Jury instructions as presently given in California and elsewhere are, on occasion, big emphasis here on elsewhere, simply impenetrable to the ordinary juror. This is their final report in 1996. The reason instructions are so often impenetrable is that they are based on the language of case law and statutes written by and for a specialized legal audience and expressed in terms of art that have not evolved through multiple languages, in many countries or several centuries. We do not seek to lose either the majesty of the law or the rich language in which lawyers and judges have expressed it. However, our work reflects a belief that sound communication takes into account the audience to which it's addressed. Jurors perform an essential service in our democracy. We are absolutely dependent upon them to apply the law fairly and accurately. In order to do so, they must be able to understand the instructions they're asked to follow. So the importance of this, you guys, is this is what Bama law is pointing out here is this is a rarity, but California was like, we're doing this even if it takes us 8 years. The instructions were prepared for a statewide committee of justices from the Court of Appeal, trial court judges, attorneys. I've never seen this as a word, academicians? Like academics, but academicians. And lay people. So lay people help put this together. They are approved by the Judicial Council as the state's official instructions pursuant to the California Rules of Court. There's a footnote there. The Rules of Court strongly encourage their use. So each instruction began with the preparation of an initial draft, followed by a subcommittee review and full committee consideration. The task force was assisted by a remarkable group of staff attorneys that included, and I don't know if these are familiar names to anybody, but Robin Seeley, Natasha Minsker, Jeffrey Shea, Melissa Johnson, Elizabeth Givens, and Lisa Lockyer. Throughout our multi-year effort, drafts were repeatedly circulated for public comment. That's cool. Chat, we could have been part of this if we did this years ago. The task force reviewed thousands of observations, and this final product reflects the input of judges and lawyers throughout California. We are grateful for the willingness of prosecutors, defense counsel, appellate specialists, judges, and justices to share their insights and the benefit of their experience. A list of people and organizations who have contributed to this undertaking follows as preface. We apologize to anyone who's been omitted through oversight. The official publisher of this work is LexisNexis Matthew Bender. Its representatives have worked closely with us to prepare the instructions and create a software platform for their usage. We have been greatly aided by their efficiency, professionalism, and commitment to excellence. We particularly recognize Bruce Greenlee for his tireless efforts in this regard. We gratefully acknowledge our predecessor. The Committee on Standard Jury Instructions, Criminal and Superior Court of Los Angeles County, published the first edition of California Jury Instructions, Criminal Cal JIC, in 1946. For 6 decades, their efforts have helped guide the deliberations of California jurors. While we've taken a very different approach to the drafting of instructions, the tremendous contribution of Cal JIC has made to the California justice system cannot be overestimated. Like the law on which they are based, these instructions will continue to change. This evolution will not come only through appellate decisions where case law precedent can be made and legislation, but also through the observations and comments of the legal community. The Judicial Council's Advisory Committee on Criminal Jury Instructions, charged with maintaining these instructions, welcomes your comments and suggestions for modification. So shout out to the Californians in the chat. Finally, I wish to express my personal appreciation for the leadership of Chief Justice George. Oh, his last name must be George. I was like, why do we just use his first name? Whose vision and commitment have infused this project from its inception, and to the remarkable men and women who so tirelessly served on the task force. So this was May 2005. So this is super cool. And we got Carol Corrigan signing off on this. And are these all the thank yous? Yeah, so you got a ton of names here. You've got the subcommittee, which all looks like mostly looks like judges. So we've got a professor here. We've got another professor. We've got a few without titles. And then former task force members. You've got, look at all these organizations that took part in this. All these bar associations, public defender's office, DA's office is, criminal justice forum, Constitution Society, tons of bar associations. You got current and former administrative office of the court staff attorneys. And I think, is this, you know, for example, if I'm helping prepare for a ruling, I think that's this position in the court. Like someone that helps prepare like the case law and does the work to get the judge ready to issue a ruling. I think that that's what this means. Those are important players if that is their correct title here. Members of the judiciary, so all of these judges. There's 2 columns now, guys, 2 columns. All of these judges helped shape this. Members of the bar, all of these attorneys. And there we go. So this is a monster 2,500 page document. And I'll tell you, I think the stuff about assault is like page number, like printed page number, not the PDF page number, 607. But if you try to do find in page, the find in page doesn't work after the first 1,000 pages. So if you're trying to search for something and don't think it's in here, if it's a statute, if it's a code that gets laid out in the second half of this document, you have to scroll and use the index to find it. You have to do it the old school way. So, let's see. Let me go backwards. Bama Law, hope you enjoyed this. I'm a layperson. I thought it was awesome that they had this. This is stuff I wish, you know, when I covered the Jonathan Majors trial in New York, I mean, we found like one random file that was a sample jury instruction for a similar charge, but it was so hard to find anything codified. I mean, New York's like evidence code, and it's a hot mess. New York is a hot mess, very disorganized, very scattered, nothing uniform. So it would have been awesome to have a resource like this for that case. Even the YSL trial over in Fulton County, state of Georgia, we hear all of this RICO. They do so much RICO, but yet we have an expert come in and we have to figure out all of this stuff relating to RICO and elements stemming from RICO charges. That, how do we define this? How do we instruct on this? So they had John Floyd come in and he was like, a lot of it, he had some great insight, but there were some other moments where he was stumped, and Whitaker was like, I looked at everything I could on that topic, and it just wasn't defined and delineated for something that they use quite often. So let's see. Yeah, Bama Law, so I would imagine, so Bama Law says, I'm used to bench notes being literally just handwritten notes. These are the commentary for judges to use. Cool, and thank you. And I think that's probably, even though there's only 1 or 2 bench notes, I think sometimes the work is pruning things down, right? And I would imagine, where was that list of all the judges? All the way at the top. Like if they came in, all these judges, and they came in and simplified and they said, you know, in all of our years, these are like the bench notes that we use for this particular thing. What are the important ones? Let's dumb it down. Let's make it digestible. I mean, we could read that plain and simple, right, chat? You know, brandishing, not a lesser included under 245. Plain and clear. Not 16 pages of an opinion or something like that you got to sift through to figure it out. Court's on break, you guys. I imagine they'll be coming back in 10-20 minutes. Maybe. I don't know. Because you never know with Lewin. But with what we just looked at, especially with Bama Law saying this is a bit more, I think this is really organized. I wonder if it reduces the wiggle room that an argumentative party would have to argue. I don't know how much there is for Lewin, or Tacopina, or Siegel. Siegel might be doing more of the arguing here. I don't know how much wiggle room they'd have to get around these basic things. It seems pretty straightforward, right? And what did you miss? So defense is rested, but there's a witness that they're calling at 1:30, and maybe that's a rebuttal witness, but I'm unclear on it. Joe Takapina mentioned, like, there's a stipulation here in relation to time management. And the judge told the jury there may or may not be a witness. We don't know yet. It's going to be out of order at 1:30. Now, out of order, I don't know if he meant out of order because we might read jury instructions to you first and then have this witness, or if he meant out of order because it's not actually going to be a rebuttal witness. Typically, if a witness is called after defense rests, it would be a rebuttal witness that's being called. So, I don't know. I do think the priority on the defense's side is they want the jury to be able to start deliberating by Thursday, to give them all day Friday, and they don't have to linger over the weekend on this. This is day 11. Yeah, day 11. Day 11. Day 11. So Auto Doctor 911, I'm not sure. Why did Levin say the prop gun was a Glock 43 replica? Not sure one like that exists unless it's a real Glock 43 with a blank fire barrel. And I'm not sure if they're talking about maybe the clear magazine, or if they're trying to go down ghost gun theory land again. I don't know. Let's see. Also, all about the shade. Do you think the slip up by Lou read 24 years will help? If there was, so the 24-year thing, I think in someone's mind, they'd be sitting there thinking, if they're going to decide that putting someone away would impact their decision, I guess 24 years could be impactful. They did get it on the record that that's not what they're planning to do, which in a way I think is a little bit inappropriate, right? Just because a prosecutor says they're not going to argue during the sentencing phase for 24 years, somebody is still technically facing a punishment that's allowable within the limits, right? So I guess in that moment, we should take it as the court also saying that the court will not seek to go for the upper limit there on the sentencing. But technically, just because someone's isn't likely to be punished a certain way doesn't mean they're not facing the possibility of it. So I thought that was kind of a hot mess the way that was handled and corrected and instructed yesterday. Okay, so Derek is saying, yeah, you can get a Glock 43 replica. So, yeah, and then it would be a possible modified prop gun. Yeah, and then the manager said that the prop was modified. Okay, so maybe Lewin's trying to get at this. Well, we heard that it was modified, and now we want to be able to make the additional argument that it could have been modified to be an operable firearm. I mean, I think that's what I'm piecing together based on what Lewin was kind of saying out loud in court this morning. And then that. And again, it would just be argument. It would be argument more than anything else because they don't have this prop gun. They can't actually, there's really no evidence on the record that it was modified to become operable. The testimony on the record is, it was modified to have like these appearances and a belt clip. So, also, before I forget, big thank you here, All of the Shade, for being a member for 5 months. I don't know if this, ultimately, if this slip up will help or hurt. Because I do think they're suggesting if the jury paid attention to him say 24 years and they're like, oh my God, I wouldn't want to sentence someone or put someone at risk of being locked up for 24 years. I do think that the court and the prosecutor made it seem like that's ridiculous. It's so far extreme that maybe they took heed to that instruction. And no updates from anybody in the court. Yeah, and so actually Linda Kenny Baden is saying it seems like a trade-off between bringing in another witness versus getting this case to the jury this week. And I really think that that's what's going on, because we heard them talk about a stipulation this morning on witnesses and timing. And that should signal to you how much of a big deal. If you guys ever see the chat saying, oh, they're trying to stall, they're trying to delay, they're dragging on this questioning to make sure cross doesn't get to happen before the weekend. It might seem far-fetched, but in practice, in reality, I mean, that stuff is strategic. Like, I like to think of, like, think how important certain parts of sports games are. Think of, like, the last 2 minutes of fourth quarter of an NBA game, right? Those final minutes, the timing, all the play calls, extremely critical, could make or break a game. And just like in a court case, you give humans that are sitting on the jury a whole weekend. They go do whatever. They're like, yes, I don't have to sit in the courtroom for 2 days. And then they come back, they might have a fresher slate. Or they might be thinking all weekend about the last thing they heard on that Friday. And it's just sitting there marinating. And whether it should be significant, whether it should have an impact or not, I'm sure it does. Also, huge thank you, Holy Moly, here to Idiot Wins. Love yelling your name. Guys, this is the chance. You get to yell idiot in the chat. Big shout out here to Idiot Wind, gifting 20 memberships, which is so much. That's like 20 new people that are ASAP something in the chat now. So big thank you here to Idiot Wind. Love it. And she's also using the cat breathing emoji. Always love that emoji. It's a classic around here. Yeah, an auto doctor saying run out the clock, stop the clock, time out. Oh my goodness. Whenever, I mean, some parts you can ignore the whole game and then just watch the last, I would say, like the last 2 minutes of an NBA game can seriously become 30 minutes, 45 minutes sometimes. So yeah, super strategic there. And you gotta save your timeouts. You can't, just like in court, you can't ask for sympathy from the judge a million times, and then maybe at the end when you really need a ruling where the judge could use his discretion in a way that's in your favor, if you've exhausted all of your opportunities, if you've pissed the judge off, it's very real. Like, that's gonna have an impact. You put yourself in that position. The whole process needs a play-by-play, a play strategy. Let's see. Yeah, I don't imagine the judge setting aside the verdict. Because, again, the fact-finding determination on whether this was a real gun or not, the jury's determining that fact. I don't think it's going to be an issue as a matter of law. The only thing I can see is if somehow they get an indication from the jury that the jury, like, the jury wants to say all elements were met, but somehow they explicitly state, we think these elements were met with the starter gun. Now we'd have a weird issue. That would be an extreme scenario. I don't imagine that happening. I actually imagine an instruction from the judge where if he saw that on the verdict form, he would explain that that's not an option on this form. They have to fill it out according to the elements presented to them in the instructions. Send them back for them to fix it themselves. But an issue like that would be a matter of law, right? So, I don't know. Yeah, I don't imagine a motion to set aside the verdict here. Let's see. Lots of love here. Lots of people yelling idiot in the chat. Love to see it. Love to see it. And I still think this is weird, especially we're shooting down. Things ricochet, sure, but something ricocheting from that angle, like if according to the testimony that it was like this, it was like a movie. Something ricocheting isn't going to go as far as something shot straight out into the wild. Or it'll hit something, it'll be stopped, and then there will be a defect. where's the other part? Why do we only have casings? Why do we only have casings? Yep, and this is it. Yep. It's possible the elements are met. The jury, as the finder of fact, could determine all the elements were met here. If they find Relly credible, if they find the police credible, if they find Relly credible on certain ways that he explains something. Oh my gosh. Kemi Bello says, hey chat, got my Beyonce tickets, now I can watch the trial in peace. Yeah, isn't it like at any time tickets like that, like stuff crashes, it's like impossible to actually make the purchase? So I feel like this is a big feat. So congratulations. I am sure you are excited. So Miss Dee, they started. They had a little bit of court discussion. It was about 15 minutes into this stream. And we've been on an hour. So if you go back 45 minutes from the point in time where I'm saying this, you can watch what happened at court. There was some like quick discussion back and forth. Rocky's not taking the stand. Defense rested their case. There may be a witness being called out of order at 1:30. Jury is currently waiting around while the judge and the parties discuss jury instructions in the judge's chambers. And then they're going to come out and read the jury instructions. They're expected to, like, within the next 10 minutes and be done with it by noon their time. It's currently 11 their time. And then by the time they're done reading this instruction, I think we'll hear whether or not this witness is going to be called around 1:30 their time. But one of the jurors, they're ending court with the jury at 3 p.m. their time today. So whatever they need the jury present for, it's got to be done before 3 p.m. So we have a question. So ML says, if they mistakenly find Rocky guilty, can the judge overrule them to not guilty? So do you mean like if they check off the paper the wrong way and then when they hear the judge say he's guilty, they're like, oh my God, that's not what we meant? I don't really know what would happen in that scenario, but if you have all the jurors saying, oh my God, that's not what we meant, and that's what you mean by mistake, I would imagine the judge would have to take that pretty seriously. If you mean they mistakenly, like, you would disagree with the verdict, you would come to a different conclusion, or the judge, if he was a juror, would come to a different conclusion. It's probably not within his discretion to do that unless he really feels that no reasonable person could have come to this conclusion. And I think that would cause a hot mess on appeal anyway. So probably not. Really, when you see the judge motion to set aside a verdict, it's going to be as a matter of law or sufficiency of the evidence. Other than that, the next step in post-conviction would be an appeal. Let's see. Are we talking about the sanctions, Michelle? Yeah, guys, chat. We got to look for the sanctions hearing for these attorneys for the tally. You know, I got this Dunkin' Donuts coffee. We don't even have court going right now. I have this caffeine for nothing. So Yak Mommy is now in line for these tickets. That's crazy. Just imagining, like, being on the other side, the tech side of it, like, oh gosh, we're down again. The servers are overloaded. Like, what a day of work it's gotta be. Idiot Win, thank you for the super, says, wouldn't you have to provide defense for deadly weapon? Oh, definition for deadly weapon. Especially because instructions semi extracts a fired cartridge and firearm is weapon from which projectile is discharged. Yeah, so there are, let's go back to, where was it? Cartridge, did they use the word projectile? Okay, So, a firearm is any device designed to be used as a weapon from which a projectile is discharged or expelled through a barrel by the force of an explosion or other form of combustion. And then a semi-automatic pistol extracts a fired cartridge and chambers a fresh cartridge with each single pull of the trigger. Yep, so they should be looking at this, particularly this. But if we get, for whatever reason, a lesser on like a firearm, because this can be assault with a firearm can be a lesser included of assault with a semi-automatic. If we end up getting a lesser, I guess both of these could be included. Now, this would be for the fact-finding determination of whether this was the object used. So this should be included, but it's for the determination of, do you think it was a semi-automatic pistol or not, rather than a semi-automatic pistol versus whatever else. So I do think that we'll see that, and they're probably arguing about this back there, about how to word it. And I would imagine, you know, for example, if this was Fulton County, if they follow these model instructions in California, what they're doing back there in that office might be quite a bit different than what we saw with Paige Whitaker, Max Shart, John Floyd, Atkins. Atkins was a big part of that as well, I think. Maybe Hilton and Doug Weinstein and Miss Persifield a little bit. They were wordsmithing. They were going through and wondering how to word this specifically. And I'm not sure that this judge is going to allow them to do too much wordsmithing. Okay, so I get what you're saying, Idiot Wind. So you're going with the angle because we're missing the other pieces. So even if they determine that it's not a prop gun, we're still missing something that would establish that this was a semi-automatic pistol because we only have the casings. We don't have the rest of the fired cartridge. So we're missing something that would prove that it's this particular thing. So rather, it seems like this might be more likely. I get where you're going. And I also wonder, this actually makes me curious if that's how they're going to word it. I do think Takapina is going to deliver closing arguments, but it's been nice, the little bits and pieces that we've heard Chad Siegel, I think on days 1 and 2, we heard him like spitting from the bench on the case law and making his arguments. And part of jury instructions is, hey, when you get back there, you're going to look at this form. They're going to ask you to consider these things. And you might give some guidance explaining or pointing them to things that they should pay attention to. So, for example, if the defense is going where Idiot Wind is going, they might mention something about, you know, you're going to be asked to consider, and they'll read out whatever language is chosen to be included. And now I want you to remember, there's no evidence that the rounds were recovered. We have shell casings, but where's the rest of it? So we could get those arguments popping in. So Derek Croissant, I get that a prop gun can still be a semi-automatic, but there's a separate statute that includes starter pistol and prop gun as a less than deadly weapon. So as an object, that couldn't be part of this. Or it shouldn't be part of it. The defense has rested. Semi-automatic firearm. Yeah, so this is going to be interesting. Who says this case is mind-blowing to me? In my opinion, Relly told one true statement. Ills was terrified. Oh boy. I think the best explanation would be that he gave the wrong estimation of whatever. So that guy Nick is saying, what even is Relly's explanation for why he didn't show up again on the video? Massive leap of logic there. I think someone could say, you know, one explanation would be he went back later than he thought, and then we heard that the officers didn't think it was necessary to gather surveillance footage past the 11:09 p.m. time frame because they thought they already had footage of Relly on video. The problem with that is now you have an investigation being tunnel visioned by something that was just blatantly incorrect. And you have a witness, a key witness, the star witness, that can't even identify themselves on camera and may have had a very self-serving reason to misidentify themselves knowingly to the police, right? So there's no explanation that cleans it up for the state's case, right? What can be explained also is it opens another door to doubt. They should be coming back, like, the judge said he wanted to get these instructions read by 12. Yesterday he said he thought it would take him about 45 minutes to read through them to the jury. Although I guess he did read a few parts already, some of the basics on how deliberations will work. But, you know, Lewin and Takapina could be back there, like, like, I don't know. I don't know. Oh, my goodness. So Nicole says, I'm torn. I believe Rocky had a real weapon, but I do not believe that Relly was injured at all. Now, the injury may or may not be the deal breaker, right? So if they try to include assault without a firearm as a lesser included, I think that's where you would go through that and say, well, you know, there's no injury cause that rises to felony assault, so these elements aren't met. But you don't specify this in your comment, but if you think that, you know, Rocky didn't do XYZ to apply force, then an element isn't met. And or if you think Rocky acted in self-defense or defense of somebody else, you would also not guilty. So oh yeah, Hiren, yes. Well, Takapina wanted to bet the judge yesterday that they weren't going to be read on time. That was funny. That was funny. Ooh, we have, hold on, Shamina. Let me go backwards. Okay, Shamina first asked, did Ills testify? He did not, and if subpoenaed, would he have to come testify? I believe Ills lives out of state. So that could cause some issues. Let's see. Where is... I'm just looking for like a quick summary. Hold on, okay, I'm going to a summary. Guys, number one is, I know this is like a thing, right? Just try asking nicely, but to see it as a step, as a, you know, you need a witness, you need to subpoena a witness, try asking nicely first. It just seems like such a mom thing or a teacher thing. Try asking nicely. Try asking nicely. Yes, I think there's a process, and you've got to go through a whole bunch of motions to try to get an out-of-state witness. I was trying to find something California specific, but I'm getting into multitasking stream mush brain. I said ask nicely. Oh my goodness. But yeah, I do think even though you can go through a process to try to subpoena an out-of-state witness, this was like a 2.5-week trial. So. Yeah, and so again, auto doctor, this was not, there was no discharge of a firearm charged here. I don't know exactly what, like, part of the penal code that would fall under in California, but I'm sure they have a distinct thing for discharge of a weapon, public place. But that wasn't charged here. Yeah, so real quick, there's a 246.3 negligent discharge of a firearm. So, but not charged there. Not charged. Hey to Britta. Britta says I'm late, but we'll catch up soon. Yeah, you'll catch up super quick. So when you get here, welcome. Welcome to the future or the present. Hi to everybody but Lewin. Yeah, super easy to catch up today, you guys, because they've been in the back. They've been fighting over jury instructions. Yeah, no updates. Super sad. I mean, we'll hear the instructions. We will hear the instructions when we hear them, but I'm nosy and I want to know. I want to know in advance. Who do you think will win? I don't know. I don't know. Juries are unpredictable. As a state stereotype, I don't imagine California to be the most friendly when it comes to the idea of someone carrying a firearm, and maybe that will make them like the starter gun theory. On the flip side, depending on the neighborhood and the demographic, maybe the juror wouldn't sympathize with somebody punching and chasing someone and then the other party not being able to defend themselves, right? So I really don't know. I really don't know. All right, chat. Eric Belcher wants to know the real question here. Everyone's favorite cereal. I'm a loser and I really like Crispix. I don't know why. I really like Crispix. And Honey O's. Or I think they're just O's. Those are some of them. I go through the motions. I change it up a little bit. I used to love Waffle Crisp as a kid. Used to love it. Used to love Waffle Crisp. I swear it tastes a little different now. We got 2 votes for Life cereal already. We got Shreddies. Captain Crunch, heck yeah. You gotta protect your mouth though. Captain Crunch will mess up the roof of your mouth. Cocoa Pops. Oh, that sounds good. There's an off-brand of Cocoa Pebbles here called Cocoa Dinobites. Oh my god, they're so good. They don't get soggy the same way Cocoa Pebbles do. They stay crispy for so much longer. Cocoa Dinobites. They have like a dinosaur, like a Brontosaurus mascot. We've got French Toast Crunch. Love that. I have a candle right now. It's like Goose Creek. It's French toast scented. It smells just like French toast. It's so good. It doesn't just smell like maple syrup. It smells like French toast. Crunchy Nut Cornflakes. Lucky Charms. Another popular one. Fruity Pebbles. The counterpart to Cocoa Pebbles. Honey Nut Cheerios. I like Honey Nut Cheerios, but I don't know. My stomach doesn't get along with them. I can eat other Cheerios, but I can't eat Honey Nut Cheerios. I don't know why. JC from the D says Captain Crunch because I really hate the roof of my mouth. Frosted Flakes. I do like Frosted Flakes a lot. Special K and used to like Crunch Berries. Hot cereal. Do you mean like oatmeal? Here Comes Drama says nothing with marshmallows. Yeah, Crispix is the bomb. I love Trix. Trix is good. Trix is good. Yeah, so KGK says, anyone talking about how Lewin got kicked out of the homicide unit and he got put on calendar duty? Good old Lewin. I don't know what day that was, but we did do a little loop-de-loop throwback on Lewin and his time at the district attorney's office. Definitely a time. Oh, Smack. So, what was the other one? Sugar Bear? Golden Bear? Because Smack had the frog, and then there was like the bear one, but they were like kind of the same, but they're different. They are different. Quaker oatmeal squares. Cocoa Puffs, heck yeah. Apple Jacks. Now I gotta say, if you get like the Walmart brand of Apple Jacks, they taste like the classic, because I don't think they did the whole grain switch that the actual Kellogg's Apple Jacks brand did. So the off-brand one tastes like the OG Apple Jacks. Another vote here for French Toast Crunch. Chex, I like Chex too. Very similar to Crispix. Cat Fink says plain Cheerios. Yeah, I like plain Cheerios. And I like to throw some banana in my Cheerios once in a while. Another vote here for Fruity Pebbles, Captain Crunch. Weetabix. Is that like... Let me see a picture to see if... What's a comparable? Let me find it. The box is kind of helpful, but... Oh, it looks like shredded wheat. I think this would be pretty similar to what we would call shredded wheat. What is Weetabix, gang? You guys have a gang for Weetabix. Oh no, tell Fulton County. Holy moly, I love it. Oh, that is good. Yeah, that looks similar to shredded wheat. Yeah, oatmeal. I used to like survive off oatmeal when I was in high school. My car didn't have heat, and my mom's house was in the Catskills, and I didn't tell my school district that I moved. So I had like a 45-minute commute every morning. So it would be really cold and snowy. So I would have like a thermos with hot oatmeal, and I would look so forward to finally like getting to the destination, parking at my school, and just like eating my oatmeal that was still hot. Specifically blueberry oatmeal. Honeycomb, heck yeah. Fruit Loops does smell really good. Frosted Flakes and Honey Oats. Hold on, we've got some serious stuff here from I Am Shout. We're going to do an intermission on the cereal conversation. Prop gun can expel casings. 2, Rally could have take the casings to use as blackmail. 3, Rally took casings back to scene after being turned down by Rocky. 4, probably why prop gun is missing. Yeah, so that's another thing that the jury can infer, right? The manager gets rid of it in January. Was it some sort of consciousness of guilt, or was it really as they said it was? Obviously, this isn't a good deterrent. We should get you armed security, because this prop gun thing isn't good, because it be your own people. So let's send it on back to this guy in New York who doesn't know what he did with it. So on one hand, it's like, I get that it can happen. I mean, I saw the Rush trial go down. They didn't seem very organized as far as production set, managing firearms. And really, I know that was like Hannah Gutierrez Reed that was convicted, and Alec Baldwin that, you know, separate trial, ended in a mistrial. But Seth Kinney, the guy that was in charge of supplying the stuff to the set, that man was a hot mess. Unorganized. Watching the body cam Dolly talks, to see him in the chat here sometimes, he went through text messages and the body cam of Seth Kinney. Stuff is all scattered around his own house. That's where he manages all the stuff that he sends to movie sets. So when I saw that, I was like, oh gosh, that could be exactly how everything that happened on the Russ set happened. Could stem back to this guy. And maybe this guy in New York that is handling this specific prop gun for the D&B video and whatever other projects he works on is another Seth Kinney, right? So on one hand, it's like, that would be a lot of disorganization at play for this story to line up, right? It'd take a lot for the story to add up about this prop gun and Relly's actions in response to it, and then what Lou Levin told us. But at the same time, I've watched all of those different pieces line up in the Rust case. So, pops or die. I do love pops. I love that they come in like that weird bag. Steel cut oatmeal, heck yeah. Keeps the texture longer. Cat fake is like, no honey nut Cheerios, I want plain. Heck yeah. Wait, Crispix are called Golden Grams? Our Golden Grams are so different than Crispix. Golden Grams here are very sweet and delicious. They're very good. They get like they're like a counterpart to Cinnamon Toast Crunch, CT Crunch. Let's see. Yeah, not giving me. It's still giving me like the US version. So yeah, very, very good. Very, very sweet. I'd be so confused going to the store. I want some Golden Grams, and they give me Crispix. I wouldn't be disappointed because I like them both. Peaches and cream is also good. Another vote for Apple Jacks. Well, Ruthie, hold on. We're talking about very sugary cereals. Welcome aboard. Hope your appointment went well. Golden Crisp. Yes, that's the other one. That's the one with the bear. Golden Crisp. There you go, Marley. Lots of love for Pops here. After Cash Money Cass was rallying the troops for Pops. Yeah, we looked at that too, Minnie Perkins. I think you had mentioned that earlier, like last week. Maybe it was a week before that already that we were looking at that. But I think you had mentioned that the coworkers, the lawsuit, the retaliatory lateral movement. He put two other staff members at the district attorney's office on calendar duty. Cookie Crisp? Heck yeah, Cookie Crisp. Yeah, so Idiot Wind says, my understanding is starter gun does not expel anything like guns used to start off races. Don't even expel blanks. I don't know. I thought that was 12E's testimony that nothing is ejected. So 12E did touch on that. But I do think there's the some can, some don't, and then they might not expel something as designed, but they can be modified to expel things. So there's a gray area there, and nobody really got into that because we don't have the actual firearm itself. Let's see. We have half the chat all in like the cereal conversation, and the other half of the chat like, let's figure out these shell casings. C. Carrera says, no, a standard prop gun, which typically fires blank cartridges, does not expel casings because blank cartridges lack a projectile and are designed to only produce a noise and flash without ejecting a spent casing. However, some specially modified prop guns can be designed to eject fake casings for added realism, though this is not common practice due to safety concerns. Yeah, I can imagine like a video where it's like zoomed in slow motion. You want to see the shell casings fly out. What was that movie that Angelina Jolie was in? The trailer was like that. They like showed her slow motion firing. Yeah, no channel says if Relly really thought it was 3 to 5 shots, why did he stop searching so quick? He found 2 in a minute and stopped looking. Yeah, and that's the thing, right? It was Relly's own testimony that he said 1 to 2 minutes and maybe 2 to 3. The first time he said 2 to 3 minutes. And then when he was asked, like, you testified that you found them quickly, and he was like, yeah, 1 to 2 minutes. And whoever was questioning him was like, well, I think he said 2 to 3 minutes, but close enough. But in any case, maximum of 3 minutes of looking, you give up after finding 2. JG says, what Angelina movie isn't like that? Fair enough. Fair enough. I do think it was Salt. Thanks, Mark. I think it was Salt. Although, yeah, exactly. Going back to JG's point, Mr. and Mrs. Smith, yeah. It's just the style. We are still waiting. I actually cannot believe they're not back. Refreshing it just to make sure I'm not crazy. Do we have a chat pinned message here from Law and Crime? Nope. Let me pull up Court TV. Sometimes Court TV will give a little update. Yeah, Court TV still has their chat disabled. So, that's weird. Maybe they have their reasons. They're back there arguing jury instructions, so, I mean, I don't know exactly what's going on, but maybe a guess. Maybe a guess. Tomb Raider is one of those games that I swore was like the coolest on PlayStation when it first came out, and then I tried to go play it a couple years later, and it's so I like can't get used to the old mechanics of it. Um, yeah, Black Butterfly Rally was never located on camera, so that tells me he never went, and it was a setup. I mean, that's where I am. That's where I am. And if the casings were a setup, then nothing with projectiles was fired. So. If they're taking lunch, this is stupid at this point. Free the jury. Free the jury. So Kemi, it says if you like Tomb Raider, try Uncharted. It's like an updated version. I mean, there's been new Tomb Raiders too. With Uncharted, I actually ended up like watching people play it, and I guess because I watched it, I was like, I don't really need to play on my own. It's like having a spoiler. But it was very cinematic. You could watch people play Uncharted like it's a movie. Do you guys want to watch something until if we play something, maybe they'll come back as soon as I start playing something else. Let's see. They literally ditched us. So we did that little clip we went back on Relly, that was direct, where they were talking about, he shot me, I felt the hot graze, and then I ran and went to Ills and used him as a shield. Seems like a different order of events than what we heard the prosecutor asking questions about yesterday. We could do some cross. We could look at what the officer that took the November 8th intake said. That was pretty short. Oh my god, Idiot Wind, I'd love to be there too. Just hearing the jury instructions. Let's do this. There's a video clip here that's 30 minutes from Kirk Anderson's testimony. That's the officer that was at the Hollywood station when Relly came in to bring in the shell casings. And it's titled that Relly said Rocky was acting fake. So why did it take me to the whole thing? There we go. So we can watch that. It's 30 minutes, and I'll keep the real court in another window. We can watch it if it comes back. So let me load this up.
Please me raise your right hand. Thank you. You solemnly state that the testimony you may give in the cause and after before this court, to the truth, the whole truth, and nothing but the truth shall be God. I do. Please take a seat and witness stand. You adjust the microphone there and state and spell your name.
Kirk Anderson, KIRKANDERSON.
I forgot to mention this to you. The clock on the wall is getting worse. Yesterday it was like 4 minutes off, now it's about 7 minutes off. So we're not going by that clock. I got a wristwatch, we'll go by the wristwatch. And I have 10 minutes before.
It's about 5 o'clock.
What?
It's about 5 o'clock. It's
Misleading. So we're going to go by, and I'm sure all your watches, synchronize our watches. 10 minutes to 11. All right, go ahead.
Thank you. Sir, would you start by telling the jury who you work for?
I work for Los Angeles Police Department.
And how long have you been a police officer for?
A little over 9 years.
Which station were you working at in November of 2021?
Hollywood Police Station.
And on November 8th, 2021 specifically, were you working that day?
Yes.
What was your assignment that day at Hollywood Police Station?
I was working the front desk.
What does that mean when you say working the front desk?
It's a patrol assignment to the desk where people come in and you take reports and help tips and stuff.
Would that literally mean you're sitting at kind of the front desk in the lobby of the police station?
Correct.
And the people that you're talking about, you take reports from, would those be citizens that walk in off the street to report crimes to you at the desk?
Yes.
On November 8th, 2021, did you interview a man by the name of Terrell Efron?
Yes, I did.
And how is it that you came to interview him that day?
He walked into the lobby of the police station.
When he came in, was he alone or was he with anyone else?
He said he was with a lawyer. There was a man in a suit that was with him.
It's not just that he told you he was with a lawyer, you also saw this man wearing a suit.
Yes.
And if you can tell the jury broadly, what was it that Mr. Efron was there to report?
He said he was a victim of a shooting and that he was shot by a known celebrity by the name of ASAP Rocky.
In addition to tell you that the person who had shot him was ASAP Rocky, did he tell you that person's true or legal name?
Yes, he did.
And what was that name that he gave you?
Raheem Mayers.
Did Mr. Efron tell you how it was that he knew Mr. Mayers?
He said they'd known each other for about 15 years, and he was part of a group called ASAP Mob.
When you say he told you that, was that Mr. Efron telling you that only Mr. Mayers was part of it, or that both of them were part of that group?
That both of them were part of it.
Before we get to the actual shooting that Mr. Efron told you about, did Mr. Efron tell you about anything that happened just prior to the shooting between him and Mr. Mayers?
Efron said that he heard that ASAP Rocky was talking bad about him over the cell phone, and that was the day prior to the shooting.
Did Mr. Efron tell you that he specifically heard the defendant talking bad about him, or that he heard about the defendant talking bad about him?
He heard about defendant talking about him.
So did he tell you that he heard words coming out of the defendant's mouth?
Objection to pleading, Your Honor. Foundational. Repeat. Objection to pleading. Foundation.
I don't recall specifically.
Did you document it in your report?
I did.
Will it refresh your memory to look at your report?
Yes.
Okay. Oh, sorry, Your Honor. Almost cat had an instructor section. Does that refresh your memory to what Mr. Efron told you?
Yes.
And did he tell you that he specifically heard Mr. Mayers talking bad about him, or that he heard about Mr. Mayers talking bad about him?
He said that he heard Mr. Mears was talking bad about him.
Okay. Did he give you any more information about how it was that he overheard that information?
He did not.
What did Mr. Efron tell you that he did after he heard Mr. Mayers talking bad about him?
He sent a text message to a friend that he said ASAP Rocky was being fake.
And did Mr. Efron tell you that that friend was a mutual friend of theirs, or just his own personal friend?
I believe it was a mutual friend.
Okay. Did Mr. Efron tell you where this encounter or incident first took place?
Yes, 6200 Hollywood Boulevard.
Are you at all familiar with 6200 Hollywood Boulevard?
I drove by there to the major intersection area.
Is 6200 Hollywood Boulevard, is that a very large building in Hollywood?
Yes,
Takes up almost an entire city block, correct?
correct.
Did Mr. Efron narrow down for you where at that building their initial encounter took place?
They said it was at the driveway.
Any more detail about what the driveway either led into?
I believe it was a parking garage.
Okay. Did Mr. Efron tell you when that meeting at the parking lot took place in reference to when the phone call was that he overheard where Mr. Mayers was talking bad about him?
Yes, the following day on November 6th at 10 p.m. is when they met in the driveway.
So, if I understand what you're saying correctly, Mr. Efron said he overheard this phone call, then the very next day is when the driveway incident took place?
Yes.
All right. Did he give you any specific date, day, or time when that meeting at the parking lot took place?
Yes, 10 p.m.
Do you remember the date?
November 6th.
And do you remember what day of the week that was?
I don't.
Would you have documented it in your report?
I don't believe the specific date is
Okay. But November 6th of 2021?
Yes.
What did Mr. Efron tell you when he when he first got to that parking garage?
So when he got there, he saw ASAP Rocky. He saw two mutual friends of his and ASAP Rocky. One he said his name was ASAP Ills, and the other one I believe goes by the name of 12E.
Did he tell you that those two men, Ills and 12E, were with Mr. Mayers?
Yes.
Okay. And then what was the next thing that he told you happened?
He said from about 5 to 10 feet away, ASAP Rocky pulled out a black handgun from his waistband and
5
told
to
him,
10 feet
"What's
away."
up now, pussy?"
Okay. What did he tell you happened immediately after that?
He then pointed the handgun at Efron and said, "I will kill you right now," approximately 2 to 3 times.
And then what did he tell you happened after that?
ASAP Ills and 12E tried to intervene and de-escalate the situation, and they all walked over together to the area of Selma and visited Elmore.
Did he tell you who, if anyone, was the first person to walk away?
They were in front of him when they were walking to that location.
When you say they, who are you talking about?
ASAP Rocky, ASAP Ills, and 12E.
All right. And what did Mr. Efron tell you he did after that first altercation at the parking garage?
Once they got to the area of Selma and visited Elmore, he said ASAP Rocky turned around and fired approximately 3 to 4 shots at Efron.
Okay. Before we get there, I want to go back to the parking garage really quickly. Did Mr. Efron tell you at any point that the defendant specifically pointed the handgun at him?
Yes.
He told you, or yes, that he did? What did he tell you with regard to that?
After he said, "What's up, pussy?" he pointed the handgun, and he stated, "I will kill you right now," at Efron.
Okay. That was when you, okay, thank you. Where again did he tell you that the rounds were fired?
At the area of Selma and Vista Del Mar,
And how many shots did he tell you he believed were fired?
approximately 3 to 4.
Did he tell you whether he was struck by any of the gunfire?
Yes, he said he was struck in his left hand knuckles area.
When he walked into the police station, you had a chance to observe him, obviously, correct?
Yes,
Could you see any injury to his left hand knuckle area?
I did see an injury to his hand knuckles.
Okay. I'm going to show you what I previously marked as People 17. You recognize it, see there?
Yes,
And does that appear consistent with the injuries that you saw to Mr. Efron?
It does.
November 8th? And you said that was to which of his hands?
his left hand.
Okay. After the gunshots were fired, what did Mr. Efron tell you happened next?
He said he ran off one direction and ASAP Rocky and others ran off another direction.
Where did Mr. Efron tell you that he went?
Eventually he made his way back to his hotel.
Now, this is also pretty important if you ask me, because this paints a little bit of a different story than what Relly came up with after he was able to watch the footage. Remember, this is November 8th. On November 9th and then on December 17th, he does 2 different interviews with the detectives at the police station, or the police officers on the day after this, and they show him some of the surveillance footage. I'm pretty sure we don't have these details that he fired one shot at me, and then I ran and grabbed Ills, and then I started using Ills as a shield, and then Ills dropped his body to the ground, and then Rocky fired another shot, and I ran out of there. It's a little bit of a different story now before he sees the footage.
The lowest hotel in Hollywood.
Okay. What, if anything, did he tell you he did after you got to his hotel?
After he got to the hotel, he said approximately an hour later he came back to the scene of Selma and Vista Del Mar, and he said he collected 2 casings off the ground.
Did he tell you at all about documenting where he observed those 2 cartridge casings?
Yeah, he provided a photo of the casings on the street.
Did he actually show you a photo?
Yes.
Okay. You said Mr. Efron told you this happened on November 6th, but he was reporting it to you on November 8th, correct?
Yes.
Did you ask him specifically why he waited to the 2 days to report this to you?
He said he wanted to have a lawyer
So
with him.
we'll switch back over.
Did you?
But again, real interesting to see these timeline switches and how Relly adjusts the details and stories with new information. All right, so we are back on the seal. Let me get the captions up because I refreshed it. So they're all right. They're up at the top. Let me close out. I have the court case open on my phone. Close that out so my battery doesn't die. Get rid of this old banner. And what do we got? Oh.
Is that the witness that was going to be is that the witness that was going to be coming in this afternoon is not going to be coming in because both sides have come to an agreement on what the witness would say. It's another stipulation. So who's going to?
I'll read it here.
All right. So listen to what he's going to say. This has been agreed to, stipulated. Go ahead.
The people in the defense stipulate that the prop gun testified about in this case would have ejected 2 fired cartridge cases as it was fired. The fired cartridge cases previously marked as People's Exhibit 32 were not fired from the prop gun. So stipulated this.
All right, the court accepts. All right, I'm going to read the jury instructions to you now. And if I just read them, I think it's not going to make sense, because you're going to get self-defense instructions, and you might think, well, why are we getting self-defense instructions? Here's why. So, and that will, I think, make it a little easier for you to.
Why are we off the record? Why are we off the record? Well, I mean, court's on record. Why are we not getting a stream? Well, we heard it. He's gonna explain self-defense and justification. So this is huge for Rocky, but that stipulation, what do you think of that stipulation? Both parties are agreeing to stipulate that the prop gun would have ejected 2 cartridge casings as it fired. And that the casings that they put into evidence, that photo that we saw, were not fired by a prop gun. So, in theory, that would mean there should be 2 casings, 2 cartridge casings, found, even if it was a prop gun. But we're getting the self-defense thing. So, I don't know if this is like some strategy where Takapina's willing to stipulate because they're putting in the eggs of their basket of, yeah, we think it was a real gun, but we're getting a self-defense instruction, so we'll take it. What do you guys think? I do think the stipulation was probably in the interest of time. Move forward to these jury instructions, which seems like they're being read without us, and get the jury deliberating. We'll have to hear closing arguments still. That will probably take the morning part of Thursday, because there's no court tomorrow. And then what do you guys think? What do you guys think about the new detail, the new stipulation? Oh my god. No, let us come back. They're kicking us out, chat. They're kicking us out. Just a bunch of question marks. Yeah, that's good. I think that's a good summation. Well, that's interesting. Oop. They just came back, Dime. Yeah, wait, stop. What? That is big. Well, that tanks the case. I couldn't hear. That's big. And depending on where you already are positioned, like for me, I'm like, oh, so maybe Relly was aware that there were 2 casings ejected and he just swapped them out with 2 different casings. Or, if you're not buying the prop gun thing, maybe you're inclined to conclude, well, so I don't buy the prop gun thing because the cartridges couldn't have been ejected from a prop gun. But there was some testimony about some modifications to the magazine. But that self-defense is really coming down to it for me, because there's enough on the record that Relly was the aggressor. To me, it looked like he was the one interested in the meetup. It looked like he was the one, despite deleting the text messages and saying, you set me up, to 2 different people 20 minutes before he walks into the police station on November 8th. It looks like he was the one with the plan in advance. I heard would have ejected. Did I hear it wrong? Let's go back and play it.
Would say it's another stipulation. So who's going to?
I'll read it here.
All right. So listen to what he's going to say. This has been agreed to, stipulated. Go ahead.
The people in the defense stipulate that the prop gun testified about in this case would have ejected 2 fired cartridge cases.
I hear would have. Would have.
Gun testified about in this case would have ejected 2 fired cartridge cases as it was fired. The fired cartridge cases previously marked as People's Exhibit 32 were not fired from the prop gun. So stipulate this.
All right, the court accepts your stipulation. All right, I'm going to read the jury instructions to you now. And
All right, so we'll go back to present time. In case they come back. Yeah, so cameraman was told to cut. Crazy, crazy, crazy. Dang, I really thought we'd be able to hear the jury instructions as they're read to the jury, even though they didn't, televise the arguments over jury instructions. So, That was a replay, Joey. Yeah, so they both got their way, right? There's a stipulation there. So strategy that both sides think they got something from it. Yeah, Pop Tot says does the and that's the thing. If you have the casings, where's the other part? Where's the rest of the ammunition? Yeah, Miranda says those casings were planted. Relly never back to the scene. That's what I got. I don't know why they cut the camera. Yeah, was just thinking the same. So Kathy says I have never in my career seen this happen. So, but we did get to hear the bit and piece that he's starting off by instructing on self-defense. And not for nothing, I talk a lot about impact, anchoring, alpha, omega, bookending, the thing you hear first. If the first thing you're being instructed on is self-defense, I don't know, it kind of seems like the judge thinks that that's a really important thing to instruct on. You just get right into the self-defense instruction before you get into the elements and the charges. So, closing arguments should be Thursday for both parties. Crazy. So we'll stay on over here. We'll refresh. Shout out to Mel for the update as well. Yeah, and I personally, I enjoy jury instructions. I enjoy hearing them. I mean, it's tedious when you have a case with like a million charges, but I mean, this is a 2-charge case. But yeah, you'd think it'd be important to show. And there are a lot of people, let me tell you. So I had a post pick up a bunch of traction. It was really that clip of Lewin crashing out, but the camera was on the defense team for the entire clip. So it got a lot of traffic because a lot of people were commenting on Rocky's look and his face and like being handsome, whatever. But there were other people that took an opportunity to comment on the case that I'm not familiar with. I suspect that maybe they're not watching the case, but nothing in their response suggests that they would be aware of a possible self-defense clause, bracket, whatever, being read in jury instructions. So if you're not televising this, there's going to be a chunk of people out in the public, out in the real world, if there is an acquittal, they might not understand how the jury got there because they're not going to understand that there could have been self-defense at play. So I think televising this stuff is super important. Here Comes Drama says there should be a camera in every single courtroom. Transparency over everything. I agree, and I mean, the technology hurdle, the burden, I mean, it's not a very high mountain to climb anymore. So, Brittany says, so stupid, this is public. Why is he trying to make everything so hush-hush? Things that have no reason to be hush-hush. Annoying. I don't know. Yeah, I'm not sure why the defense agreed to that, except for a strategy on time management to not call this witness in at all. So, yeah, and honestly, guys, this is very true for Always Forever for Life. This might be really true. This might be it for today, you guys. I don't know if they're going to give us a court feedback. It's just going to be me in the law and crime background picture here, hanging out on a stream. Who knows if we'll get back for anything beyond just, all right. Although I do think that there might be some planning with the attorneys after the jurors leave. Remember, the jury, they're not going to call this witness. Maybe they'll get into one of the closing arguments today. I don't know if that's part of all of this being worked out. I don't know. But this might be the end of anything important as far as what they'll turn the camera on for. And also make sure you go and follow Mel. She's summing it up here. If jury does not believe the gun was real, Rocky would be acquitted. If the jury believes the gun was real, they can consider self-defense. So that's a summary of what was just instructed on. And this is important. We've talked a lot about pathways and keeping the pathways open, where because the defense did not take an affirmative defense, if they took an affirmative defense, the jury wouldn't have to determine if the gun was real. An affirmative defense would say, we're not disputing these elements. We just want to argue that bing, bang, bong, it was justified under the theory of self-defense or defense of others. But the jury is able to consider these two pathways as we talked about, which I think this is, in retrospect, this should give great insight on why the defense approached the case in this way. I'm not sure. So, I mean, it seems like that was coming in, this new exhibit, picture of the casings, or the ones that Relly brought in. I mean, there was a picture already entered into evidence of the casings. I'm not sure. Emotional balance coach E says, I believe it was self-defense because Relly said it was. On a call, right? On a recorded call. Yep. If it's self-defense, that means not guilty. And what I think is really interesting about the jury instruction here with California, it's the element of self-defense is kind of worked in. It's like baked into the cake. In some other states, it'll be like, do you find all of these elements? Yes, 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 yes. If you found all these elements, then consider, was the defendant justified in this because blah, 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 blah. And it's like a separate little blurb. But self-defense is actually incorporated in the negative sense. You have to find that force likely, the semi-automatic firearm, the object was a semi-automatic firearm, and that the defendant did not act in self-defense. It's baked into the whole of the instructions. Yeah, so Idiot Win says, not the defense evidence on the record that it would have ejected a projectile. So where is the stipulation coming from? It seemed to be a contested fact. I don't know. And I hope they clear it up in closing. I'm not sure if they can do that. I'm sure that would bring an objection from Lewin if in closing they try to argue that there were no casings, this gun would not have expelled casings, and we submit to you that that Terrell Efron brought in separate casings from a totally separate matter and set up this whole frame job. I think the state would object. Yeah, this is true too about federal courts. The federal courts mandate cameras everywhere except in their own domain. I hate federal court cases. Because if somebody's not there reporting on it, it's just like, it's dark. Yeah, and Fletch says with those instructions, I can't see there being a guilty verdict. And I still think it's impactful that the judge came out and said, we're going to talk about self-defense, chat. They're speaking to the jury. The jury is the judge's chat. You know, I think people put a lot of trust in judges. If a judge gives a hint of a lean or a focus point, I think the jury is usually in tune with that. So I think it's no small deal that the judge is like, all right, welcome back. Let's talk about the self-defense phrase. Yeah, Miranda A says, and the modification put it into question. And that could be a thing too. I mean, maybe there's room to argue that in closing argument, right? You know, prop gun typically wouldn't fire, but we heard there was modifications. I don't really know the specifics of the stipulation. Empress Fox, you'll be with us in no time. There was a lot of break downtime today. Yep. Let's do a refresh here on our fellow court watchers and the journalists that are covering this trial. Just a reiteration, shout out to Classy here in the comments. Just a reiteration here from Kathy that the jury is instructed they must find the gun was real and not a prop gun to find guilt. If I were on this jury, I'd have reasonable doubt about the gun. And let's get this retweeted. And Valerie, if they do believe it's real, they can consider self-defense. Definitely sounds good for Rocky. And let's help this person. Nope. No more 130 witness. And I also love, let me go backwards and find it. Linda, you guys know Linda Kenny Baden. She is a criminal defense attorney. She's done a lot of high-profile trials. She made a comment on X today that trials are living, breathing things. Things can change, and you have to make strategy decisions, just like a coach in a sporting game. You have to make play calls, and you might need to make them quick. So all of this about a witness, maybe no witness. Yes, so trials are living, breathing things. For instance, in Aaron Hernandez, we made a decision not to call Bill Belichick, speaking of sporting games, who was late in trial calling court because we felt jury had heard enough and didn't want to delay with calling another witness. Timing's important. And again, think about the YSL trial. A huge strategy when it came down to being just Doug and Max left as the attorneys. It was just Shannon Stillwell and Diamante Kendrick. We had months and months of witnesses dragging out the jury's time. They said, look, we're not even going to call witnesses. We're not going to put on a case in chief. That was a huge strategy decision. And it might have been different if the plea deals worked out differently or if the state presented their case more quickly. But they felt like they covered all the bases through cross-examinations. And I think you guys in the chat, for the most part, would agree. But big strategy call there. They said, we don't want to waste any more of the jury's time. Let them get to it. And holidays were approaching. Remember, we had the verdict right around Thanksgiving. So, oh, and also make sure, here is Linda Kenny Baden on X. Okay, so Bama law says affirmative defense requires stipulation that gun existed. They may argue prop gun is enough. Standard is would a reasonable person believe life is in danger. Interesting. JC from the D. So I would have missed this. The manager on the witness stand yesterday said that the rounds that the prop gun used were crimped and that the ones that Relly brought in were not crimped, so they are not from the prop gun. Yes, Bama law also, affirmative defenses are usually required to be pled on front end and not in closing. And, sometimes there's arguments with the judge allowing certain affirmative defenses. I know Sarah Boone, we saw issues over relying on the battered spouse defense. Defense had to file notice of intent that they plan to rely on that type of justification, which is saying, for Sarah Boone, yes, I killed my boyfriend, I did it, but it was justified because of this theory, this legal theory. And Courtney Clenny going for the same thing. She, back in October, I believe, filed a notice of intent to also rely on battered spouse as a defense. And she was looking for an affirmative self-defense anyway, but I think they're choosing the battered spouse to justify some other things. There's going to be some things that Courtney Clenny needs to explain if she wants to be believed that she was not the aggressor in the moment, in my opinion, based on what I've looked at in that case. And because you're leading on the front end with it, think about how pissed off Lewin was to hear about this prop gun theory and some last minute disclosure. Again, a lot of the defense's strategy here has been to not show their hand until they have to. And yesterday we heard they showed their hand late. And the judge is like, I don't think it was inadvertent that you didn't disclose this thing over to the prosecutor, right? So a bit of an oops there, a bit of too much. Yeah, Karen Reed, not till April, but it's February 11th. That's not that far away. Personally, I don't know if I'll squeeze in other cases. I'm gonna be pretty focused on work between this and whatever else is next. There's still some YSL. There's a hearing. What was the YSL hearing? When is the pretrial conference for YSL? I know they want the return of the juror questionnaire. April 15th. March 27th. So March 27th, there's going to be a hearing in YSL 2. The trial itself for YSL 2 is moved back to the summer because they wanted to make sure an attorney could stay on board. So they're pushing that trial back. They think it's going to start after July 4th. Like, they'll do jury selection before July 4th, but won't actually kick off with opening statements until after the July 4th holiday. So, but we will look at that hearing in March. I'll definitely make time for that. I think the property hearing, the 20th, let's see. I put it in my calendar. So instead of me just guessing, let me look at it. Let me look at my calendar. So Friday the 21st, Jeffrey Williams civil forfeiture hearing. I think 10 a.m. I usually put it in the title, but I didn't. But I scheduled it for 9:45, so it probably starts at 10 a.m. And then if Diamante Kendrick, if we need to have a case management hearing, that's slated for February 26th. I think that's also 10 a.m. That's 10 a.m. And then there was a Supreme Court case. I don't know if this is up your alley, guys, but there's a Supreme Court case. SCOTUS. Federal, like United States Supreme Court, is going to be hearing an issue where there's a circuit divide. They're split. The circuit courts, they can't decide what they want to do with the existing case law. But it involves sentencing guidelines when it comes to violations of release. So say, for example, parole, probation, you've got your special conditions. If you violate it and you have to have a hearing and, the people are moving for revocation, when the judge determines sentencing because of whatever violation, some circuits say the judge can consider the nature of the offense that you have not had a trial for. So the new offense that's pinging an issue with your probation or parole. You have not had a trial for the offense that's causing the red flag as a probation or parole violation. Some circuits are saying the judge can consider the facts as alleged when determining the sentencing for the violation. Other circuits say the judge should be limited to considering, the violation itself, the fact that you violated, and whatever the sentence and conditions of the probation or whatever terms of special release were. So I thought that would be interesting to pay attention to. It won't be a stream, it'll be like oral arguments. You can listen to the audio of it and we'll get to hear what's argued. So I think that'll be interesting. That's going to be on Tuesday, February 25th. I don't know how long I expect that to take, but we can either tune in live or we can watch it on replay that evening. So take a look out for that. The case is Esteras versus United States. Correct. Allegedly, maybe they are not going to sever Demise McMullen. They're not going to sever him. They're going to try all three together still, but they're just going to push the trial back. Okay, so, and I love this stuff because I don't know it. So Auto Doctor says crimped shells would expand back out when fired, but are usually longer and can still see difference. And I'm a complete newbie there. I'm a complete newbie with this stuff. So even yesterday, I mean, I was just like, you know, I can picture myself fidgeting and trying to put things in a magazine, and I'm like, oh, these ones fit, these don't. But in the chat, people that are more experienced with firearms are like, hey, you know, you're actually supposed to practice filling mags up all the way and get used to, like, become proficient in filling up a mag quickly, reloading. So I was like, oh, that makes sense. So it's always good to hear from you guys. And before I forget, you know, I'll be missing stuff, my bad, chat. The Honorable Yeah That said, after YSL jurors talked about not liking Love. So Adrienne Love and her yelling/aggression. I wonder what this jury thinks about Lewin, considering 7 out of 12 jurors are women. You know what? Good point. Good point. Like, I don't like being yelled at. I don't like dealing with someone that has to yell when we're debating something. I feel very much like the Patrick Star meme where Patrick Star just sits there like, all right, if you're going to do this, you can do that, but I'm not participating. I'm not engaging with it back. So good point here. Very interesting that, you know, 7 jurors are women. What do you think, summarily, with a jury that's more than half women would think of Lewin? And again, they might not have liked Tacopina, but the Tacopina's, like, demeanor, Lewin, in contrast, watered that down. He washed away the way that Tacopina could have came off to a jury. Like, if Mr. P was running this whole case, sure, he might be a little dry in his delivery, but there's a difference between something being dry and boring and something irritating you, grating, grinding your gears. I will at times get a visceral reaction to what John Lewin was doing in the courtroom. I had a headache yesterday. I had a headache yesterday. And maybe it happened because I had a headache for another reason. But it happened while I was listening to Lewin screaming at the witnesses. So, great point here. Let's see. Yeah, Shy Gal 8 says I like Tacopina from the get-go. I do as well. And I think California, busy courtroom, okay for boisterous personalities. I can see why he might not be the best attorney for, like, a small town case, right? But I liked him. I think he's fine in this setting. And even moments where he could have been too over the top, in contrast to Lewin, no big deal. No big deal. So, and you had to stop listening to Lewin. So there you go. I mean, this is a great point, yeah, that. And, you know, I always feel like people tippy-toe. They don't want to talk about how women might look at something or how men might look at something, but we can't play ourselves and just act like the demographic makeup of a jury doesn't make a difference. Sure, we can't say that just because 7 jurors are women, that all 7 of those jurors are going to think the exact same way. That's never the point that I think anyone in this chat would be making. But there's important considerations, and we can't be naive about that. And I think in this case, because of Lewin, not even because of the evidence or anything on the record, but because of Lewin, this could be very helpful to the defense. And the firearms instructor is one of these women. So, Idiot Wind says, and let's pull that up, the bench notes. Let me get this over to you guys in case you want to read it, because I think it's far gone from the chat. Is it Justia? Again, if you want to, this is the short, this is the relevant. We didn't get to hear the jury instructions, but it's going to be some combination of some of the elements lined up in this nice little thing that California has put together. And I love that Idiot Wind is so into this. So where was the Godwin mention? All right, so give the bracketed portion that begins with in deciding whether, if the object is not a deadly weapon as a matter of law and is capable of innocent uses. So, Idiot Wind says, if determining whether a weapon is deadly requires resolution of factual issue, must give both bracketed instructions. And this is why I would love to see it. But again, I think it's, you know, if they're only able to charge that it's either a semi-automatic firearm or not, which from what Mel and Kathy Roussan have reported, it seems like that's where the judge went. That's a semi-automatic firearm is inherently deadly, so there is no fact finding on inherently deadly. And because we have a different code entirely for 244.5 for stun gun and less than lethal, let's see. Oh, I don't think this page is searchable. That sucks. Oh, wait, let's look. There's actually information in here on that. Let's go to page 607. And work backwards to 244.5. Okay. Oh, wait. This is subsection C. Hold on. We just want the regular. I don't know where it was, because now it's getting into types of persons. And part of this document isn't searchable. So for whatever reason, it's only giving us 244.5 when it's against a peace officer. But the underlying statute here, stun gun or less lethal weapon, you know, a less lethal weapon, a starter gun, prop gun. We're back. Court is back, I think.
Please be here at 9:30. Outside the
9:30.
courtroom doors, 9:30. Is that a problem for anybody? All right. At 9:30, or as close to that time as possible, we'll have you come in and you'll hear the submissions of counsel. As I tell you each time, please keep an open mind. You have not heard everything. You have not begun your deliberations. And please do not look at anything on the internet regarding this case or look at anything in print media. All right, have a good day tomorrow. See you Thursday, 9:30.
We're starting super early. 9:30. So that'll be 12:30 Eastern, you guys. We'll keep this up in case they come back. Sorry I can't find 244.5 without, but my point going back to Idiot Wind here is there is no fact-finding issue. It's not a factual issue to determine whether or not a semi-automatic firearm is inherently deadly. As a matter of law in California, it's already defined that way. And since they didn't charge Rocky under 244.5, and it's not a lesser included, there's no need. The jury isn't going to be asked to make a determination on a statute. All the elements met assault with a less than lethal weapon. It's not on the table. So again, those pathways are...
I've asked Alex to generate a copy of the jury instructions for each one of you.
And for the public.
Remember, 9:30 on Thursday. Mr. Steve, anything for the record? Mr. Tackleton, anything for the record?
For the record, no.
Mr. Palome, anything for the record?
No, Your Honor.
All right, we're off the record. See you Thursday.
I said the record, no.
You know what? They're off the record now, but you never know. Who knows? They could come back. But let me correct the way I'm speaking. See, they're back. Why are we back? All right, maybe we're not. It wouldn't be an ASAP Rocky trial day if we didn't have to guess 3 times if we were actually done or not. But let me correct the way I'm saying it. What I mean, Auto Doctor, so Auto Doctor says prop gun should not be considered less than lethal either. It's only a weapon if it's used in a way to cause bodily harm. Only a deadly weapon if used to cause serious bodily harm. And those would be fact-finding issues. This is a good clarification opportunity for me. They would be charging it as if he was using a less than lethal weapon in an assaultive manner under 244.5. And then the jury would probably have this fact-finding issue. Was the starter gun being used in a manner that could cause serious bodily harm and or death? So thank you for that. That's an important distinction. Really, I was tunnel vision focused on the difference between 244.5 and 245B. So big thank you again to Idiot Wind. I'm loving that you are like all in this. Guys, if you want to dive in, again, check out, if you go to this link in the chat, you can get this monster of a PDF and check it out. Check it out. Tons of information in there, all related to California Penal Code. But you know, there are lots of California cases out there. A lot of it could be interesting. Black Butterfly also says, Relly premeditated and kept casings from the range. So this is in response to this additional element that the judge has given. The judge has charged the jury with this self-defense or defense of another instruction, where the jury must find the elements above and the defendant did not act in self-defense or in defense of others to find the defendant guilty. The jury must find that he did not act in self-defense or defense of others to be able to find him guilty. If they think he acted in self-defense or defense of others, actually I don't know if both of these were read, but we know that self-defense was charged for sure. If the jury finds all of these elements met, whatever was given to them, and this was not met, that's an acquittal. So in relation to this here about self-defense, Black Butterfly says, Relly premeditated and kept casings from the range. When he saw them, it was lights, camera, action. That's why he had the unwarranted pep in his step. The hop, skips, and the jumps. Super new. He knew. I'm just going to skip around. Whenever there's information that comes out, I'm going to study it, match my story to it. Again, he changed his story from November 8th to November 9th as he's able to watch the surveillance video. Then he's changing his story, adding in details that he didn't report the day before. He also, to me, seems like he practiced his testimony for trial in the last 2 weeks by revisiting one article that was published by Megan Cuniff in November of 2023 after the preliminary hearing where he testified. He repeated sound bites that were memorialized in that article. To me, this all, and that's not something the jury would know. They did hear, some statements read back from the preliminary hearing, but they don't know that Relly was out here sharing this news article, interacting with a post about this news article, clearly aware of a news article that he could have been reading to get his story straight. Although they did hear him say he was going back through his Instagram account and had to come back and correct the record after the weekend about this gun range location, where he was at this gun range, right? Because he had to get his details straight. So they did hear that. They did hear that. But I agree, Black Butterfly, this is where I'm at. To me, it doesn't really matter. I feel like if I was sitting back in deliberations, I'd say, look, here's my take. We might have different opinions, and I'm not sure if you can persuade me one way or the other, maybe you can, on whether or not it was a starter pistol or semi-automatic firearm, and that the state proved their case, these elements, beyond a reasonable doubt. But even so, I'm firm on this one. I'm firm that I'm going to say, no, this element is not met. I'm not going to be able to agree that the defendant was not acting in self-defense. I think he was acting in self-defense. So what about you, rest of the jury? So that's where I would go with it. And I think if Black Butterfly was back there with me, that would make 2. It would be me and Black Butterfly there for sure. Touche says, I've been very in and out, and I've never understood why those shell casings from an accusing witness with no verifiable chain of custody has carried so much weight, a scary precedence. And I think the biggest impact of this stipulation for the state is maybe it gives us an explanation for why there's shell casings and not the other components. Nobody else found anything. It's weird to me either way. Something about it isn't right. But again, when it comes down to it, that debate doesn't matter. In fact, there could be 6 jurors that say that's absolutely a real gun, and 6 jurors that say there's no way that was a real gun, or that the state met their burden to prove it was a real gun. And all 12 could agree that element 5 is not met, that Rocky did act in self-defense. So yeah, Violet says in reality, Relly never got shot. And I think there's an issue there, though, because with this, it doesn't really... Again, we're looking at when the defendant acted. He had the present ability to apply force with the semi-automatic firearm to the person. And that force doesn't necessarily need to mean that he got shot. Right? So that wouldn't really clear this up. I feel like this would be more relevant if they were charging felony assault versus simple assault. You know, the injuries of a scraped knuckle, finger, would not rise to the level of felony assault without this firearm attachment. So they returned. Yeah, quick summary there. They're going to be back at 9:30 Pacific on Thursday, you guys. So that's going to be 12:30 on Eastern time. So we'll be starting a little bit early on Thursday. No court tomorrow. Again, we're going to get closing arguments, and then jury is going to be able to deliberate. Let's see if, do we have any insights from... Let's see. Day's over. So this is the last update from Mel. Nothing about specific jury instructions. However, I know I'm about to link her ex, but let me also get her YouTube channel. You guys should all be following I'm Not a Lawyer anyway. The way she does recap content is so efficient and fun. I think you'll love it regardless, but especially since she's in the courtroom, she will probably do a video summarizing the very limited court time on the record today, but important nevertheless with these jury instructions. And I do believe she's on TikTok as well, under I'm Not a Lawyer But let's get you her YouTube over here. Hit that bell so you can see when she either goes live or publishes a video on it. But that's really the ending summary that we've got here. Judge mentioned self-defense, instructed the jury on self-defense, and that's huge, that's critical. So, also, holy moly, K. Schmidt rounding it out here, gifting 5 memberships. Let's get K. Schmidts in the chat. Good to see you. Hope you are doing well. And also, you know, are you guys getting snow yet? Anybody that's up in the north? Has it started snowing by you guys? Because we opened this stream talking about weather. We've got some cold weather hitting, which is crazy to me. It's super warm here right now. I believe, let me check my phone and see if it was successful. I believe we had a rocket launch today. Yeah, they had a rocket launch earlier this morning, I think. Oh, that's an old one. Yeah, 2:05 p.m. I think I may have heard that. I think I thought it was just bass and rumbling when we were watching the replay an hour ago. I thought it was coming from the court. But about an hour and change, an hour and a half ago, there was a rocket launch here. So that explains some noise. And, yep, we've already got the snow in Baltimore. Yes, in Virginia. Trikeisha is still dry. No snow in her part of Maryland. So, very interesting. Put on your hat, Trikeisha. It's coming your way. Touche says, I'm in the Northeast and nothing yet. Oh, Minnie has the cold rain in Arkansas. That's kind of the worst, where it's like, it feels frigid because it's cold, and then because it's rain, it like it'll soak your clothes faster than snowflakes would. Ugh. I think that's worse than just being like a couple degrees colder where it's actually snow. So Jazzy has some snow there in Virginia. Trikeisha's starting to see the flurries. And then Violet in Greensboro, North Carolina has the cold rain with prediction of sleet mix. Yeah, that's the gross, rough, especially if you can't see it on the road. Always hated that. Emotional balance coach says, it's just cold here in Brooklyn. And then rain in Georgia. Yes, you guys got a little bit of the cold. We're still stuck in, it's like 78 right now, I think was just on my phone. Which is, you know, never thought. I grew up with winters my whole life. My birthday is in March, and there would never fail. There'd always be like some late March snowstorm around my birthday every year. But now that I live in Florida, I'm like, it's February and it's like 80 degrees. That's crazy. Lots of snow in Montreal. And again, hope you guys are staying warm and cozy. I miss the snow a little bit, but at the same time, dealing with it for a whole season, it gets annoying, it gets tiresome, you get stuck in the house for it. It's pretty, but it can be quite annoying. Where do you guys want to go and hang out? Let's see. I will say anyone that's talking about the ASAP Rocky case, probably going to be winding it up, but if I see someone that's still live talking about ASAP Rocky, Justice Served is live talking about ASAP Rocky, and so is Taylor Umbridge. And I can't like see a preview when I'm in the redirect window. I can't really see what they're doing on screen. I can just see the thumbnail of their currently live stream. So we can either go to one of those. I do also see, let's see. Nick Starro is doing YNW Melly trial read through of, and it cuts off, I'm assuming, a new motion. And then there are like 8 channels covering the Megan Boswell trial, which is on day 6. That is going to be, I think, a 6-week trial is what I heard. I could be mistaking it with another case. So I don't know if I'll be able to follow that one. The facts seem so bad in that case. I can't imagine anything but a guilty verdict over there. And sometimes when cases just seem traumatic, I don't want to say it's uninteresting to me because I don't want people to think that I think it's unimportant. It's different. But when something's like extremely taxing emotionally, it's a child, death of a child. It's a lot to pay attention to for 6 weeks. 6 weeks. So, shout out to the March babies. And you guys are so talking about the weather. You guys don't know where you want to go. Let's see. Are you guys interested in the YNW Melly thing? I'm thinking of that because you guys do ask me about YNW Melly, but I always just follow Bryce Boom Paulson on X for updates there. Yeah, Lucinda, the case is horrific, and I mean, it just seems the facts are super bad. So again, the lack of interest there. I'm getting some yeses there on the YNW Melly. So again, a quick rundown if you want to go check out. I see for Megan Boswell, I see The Defense Rests, Survivor Speaks, Criminality, The Alternate Corner, and Grizzly True Crime are all doing the Megan Boswell trial, and Recovery Addict. Those are the 6 that I see. And if you guys want to continue watching ASAP Rocky, Justice Served TV with Linda Kenny Baden and Michael Bryant and Taylor Umbridge, we're going to have this redirect over to Nick for YNW stuff. It seems like the prosecutor is on some funny business again for trial 2. So I think stuff like that is interesting. I think there's an overlap with interests in this chat for prosecutorial conduct or misconduct. So we'll check that out. We'll get over there. And remember, no court for ASAP Rocky tomorrow. If I can get a lot of work done today, we can get together and rewatch opening statements tomorrow. If not, or in any case, see you guys Thursday, earlier than usual, 10:30 Eastern, 9:30 a.m. Pacific. So you guys take care and see you over with the YNW Melly stuff. Definitely getting crazier. And thanks for hanging out for such a non-productive day in court. Bye, guys.